proceedings, let me briefly reflect on the national context that makes today's meeting. As you are aware, in recent weeks, higher education in our country has become the focal point of a major national debate on caste discrimination and institutional equity. This follows the UGC new regulations 2026, that is, promotion of equity in higher education institutions. These regulations mandate all the universities and colleges to establish equal opportunity center and equal equity committees, equity squads, and 24-hour equity helpline to address caste-based discrimination. This regulation expands procedure to include other backward classes also. Also, to strengthen grievance redressal mechanism and empower the UGC to monitor the compliances and penalize non-compliant institutions. However, after this regulation, there have been petitions filed in the Supreme Court and sporadic protest against these new regulations. Recently, the Honorable Supreme Court issued directives staying the implementation of the new regulation. Now, these judicial interventions and regulatory shift, we fear, may weaken the institutional mechanism and for institutional mechanism for protecting the marginalized communities. Potentially, it is disturbing the broader framework of the social justice and equity in higher institutions. At the heart of this debate lies a national and moral question. Is India's legal and education system promoting equality? It is within this critical and evolving national backdrop. Today's meeting seeks to examine the core question: does the Supreme Court support caste discrimination in higher education institutions? With this background, இந்த கூட்ட நிகழ்ச்சிகளை தொடங்குவதற்கு முன் இந்த பின்புல தகவல்களோடு இப்பொழுது அனைவரையும் வரவேற்க மூதறிஞர் குழுவின் செயலாளர் மாண்புமிகு செல்வராஜ் அவர்கள் வரவேற்க அழைக்கிறேன். மாண்புமிகு செல்வராஜ் அவர்கள் வேளாண் சட்டமன்ற செயலாளராக மூதறிஞர் குழு செயல்பாடுகள் சிறப்பாக அமைய குழுவின் செயலாளராக செயல்பட்டு வருவார். ஐயா அவர்களை வரவேற்புரையாற்றி அழைக்கின்றேன்.
Recording in progress.
சாதிய பாகுபாட்டை உச்சநீதிமன்ற மாநிலங்களாகின்ற பகுதியில் நடைபெறுகின்ற இந்த சிறப்பு கூட்டத்திற்கு வருகை இருக்கின்ற உங்கள் அனைவருக்கும் என்னுடைய முதற்க நன்றிகளான வணக்கத்தை தெரிவித்துக் கொள்கிறேன். இந்த சிறப்பு கூட்டத்தில் தலைவருடைய தலைமுறையோடு 3 அறிஞர்கள் அல்லது சிறப்புரையாளர்கள் பேசிருக்கின்ற காரணத்தினால் நான் வரவேற்புரையை மட்டும் நிறுத்திக் கொண்டு இந்த கூட்டத்திலே ஆசிரியர், திராவிட கழக தலைவர், தமிழர் தலைவர் என்றெல்லாம் நாம் போற்றுகின்ற நம்முடைய மதிப்பிற்குரிய ஐயா அவர்கள் சிறப்புரையாக இருக்கின்றார்கள். காணொலி வழியாக அவருக்கு என்னுடைய மூதறிஞர் குழுவின் சார்பாக தெரிவித்துக் கொள்கின்றேன். தமிழ்நாடு மூதறிஞர் குழு தன் புலவரை உச்சி முகர்ந்து வரவேற்கின்றது. இச்சிறப்பு கூட்டத்திலே பேராசிரியர் சுகதேவ் UGC முன்னாள் தலைவர் அவர்கள் காணொலி வழியாக சிறப்பாயிருக்கின்றார். சிறந்த இந்திய எக்கனாமிக்ஸ் டாக்டர் அம்பேத்கர் நேஷனல் அவார்டு, பத்மஸ்ரீ அவார்டு, ராஜீவ்காந்தி அவுட்ஸ்டாண்டிங் லீடர்ஷிப் அவார்டு போன்ற பல்வேறு அவார்டுகளை பெற்று இன்று டெல்லியிலே இருக்கின்றார். அவர் டெல்லியிலிருந்து நமக்கு பல்வேறு கருத்துக்களை கூற இருக்கின்றார். 75 ஆராய்ச்சி கட்டுரைகளை நேஷனல் லெவலிலும் இன்டர்நேஷனல் லெவலிலும் அவர் எழுதியவர். மிக சிறந்த கல்வியாளர். அவரையும் தமிழ்நாடு மூதறிஞர் குழு சார்பாக வருக என வரவேற்கின்றேன். திராவிட கழகத்தின் வெளியுறவு செயலாளர் திரு கருணாநிதி அவர்கள், அவரும் சிறந்த கல்வியாளர். ஆல் இந்தியா பேக்வர்ட் கிளாஸ் ஃபெடரேஷன் என்ற அமைப்பிலே ஜெனரல் செக்ரட்டரியாக இருக்கின்றவர்கள். மிகவும் பின்தங்கிய வகுப்பினருக்காக அவருடைய உணர்வுகளை புரிந்து அவருடைய குறைகளை களைவதற்காக போராடி உழைக்கின்றவர். அவரும் அரங்கிலிருந்து இந்த சிறப்பு கூட்டத்தில் பேச இருக்கின்றார். அவரையும் அன்பு கூர்ந்து தமிழ்நாடு முதலமைச்சர் குழுவின் சார்பாக வரவேற்பதில் மதிப்பு அளிக்கின்றேன். நம்முடைய தலைவர் முனைவர் சுவாமிநாதன் தேவதாஸ் அவர்கள் பேராசிரியர் சுகதேவ் அவர்களுக்கு நெருங்கிய நண்பர். அவர் மூலமாகத்தான் இப்படி ஒரு மீட்டிங்கை உடனடியாக ஒரு குறுகிய காலத்தில் நாங்கள் ஏற்பாடு செய்தோம். அவர் இந்த சிறப்பு கூட்டத்தில் தலைமை தாங்கி அதிக கருத்துக்களை கூற இருக்கின்றார். அவருக்கும் என்னுடைய வரவேற்பு, என்னுடைய நன்றி கொண்ட வணக்கத்தை தமிழ்நாடு முதலமைச்சர் குழு சார்பாக தெரிவித்துக் கொள்கின்றேன். ஒருங்கிணைப்பு மற்றும் நன்மைகளை நடத்தவிருக்கின்ற தமிழ்நாடு முதலமைச்சர் குழுவினுடைய துணை செயலாளர் மாணவிகு பன்னீர்செல்வம் அவர்களையும் வரவேற்கின்றேன். இந்த சிறப்பு கூட்டத்திலே தமிழ்நாடு முதலமைச்சர் குழுவினுடைய பொருளாளர் முனைவர் திவாகரன் அவர்களும், செயலாளர் வெங்கடேசன் அவர்களும், செயற்குழு உறுப்பினர்கள் திருவாளர்கள் நாகராஜ் பொன்னுசாமி அவர்களும், மாணிக்கம் அவர்களும் மற்றும் பல்வேறு நண்பர்களும், முக்கியமாக திராவிட கழகத்தின் துணை பொதுச் செயலாளர் பெரியார் அவர்களும் இங்கே வந்திருக்கிறார்கள். அவரையும் வரவேற்கின்றோம். இந்த நிகழ்ச்சி மிக சிறப்பாக நடைபெற வேண்டும் என்றால் தேவராஜ் அவர்களுடைய ஒத்துழைப்பு மிகவும் அவசியம். அவரை வரவேற்பதிலும் அவருக்கு பணியை செய்வதிலும் என்னுடைய நன்றியையும் நான் இந்த குழு சார்பாக தெரிவித்துக் கொண்டு, மீண்டும் இங்க வந்திருக்கும் தனித்தனியாக கூறுவதற்கு போதிய நேரம் இல்லாத காரணத்தினால் பல்வேறு அறிஞர்கள் இருப்பினும் அவர்களுடைய பெயர்களை குறிப்பிட முடியவில்லை. தயவுசெய்து மன்னித்துக் கொண்டு நான் ஒரே ஒரு கருத்தை மட்டும் சொல்லிக்கொள்ள ஆசைப்படுகின்றேன். டெல்லி, மகாராஷ்டிரா, UP ஆகிய 3 மாநிலங்களினுடைய மாணவர்கள் SC, ST, OPC மாணவர்கள் படிக்கின்ற IIT போன்ற மத்திய அரசின் உயர்கல்வி நிறுவனங்கள் படிக்கின்ற மாணவர்களை செய்து அவர்களை துன்புறுத்தும் வகையில் இருக்கின்ற காரணத்தினால் 15 ஆண்டுகளுக்கு மேலாக அவர்கள் கஷ்டப்பட்டுக் கொண்டிருக்கின்ற காரணத்தினால் பல பேர் இறந்து விட்டார்கள், பல பேர் பாதி படிப்பை விட்டு விட்டார்கள். இந்த நிலையிலே UGC ஒரு ஒழுங்கு விதிமுறைகளை ஏற்படுத்தி அவர்களுக்கு பாதுகாப்பு கொடுக்க வேண்டும் என்கின்ற ஒரு விதிமுறையை வகுத்தது. அவ்வளவுதான், சட்டம் கூட இல்லை. ஆனால் அதனை அவருடைய 3 நாள் போராட்டத்திலே உச்ச நீதிமன்றம் தடையாளை பிறப்பிருக்கிறது என்றால் இது சமூக நீதிக்கு எதிரான செயல் அல்லவா, அரசியல் அமைப்பு சட்டத்திற்கு எதிரானது அல்லவா என்று ஐயப்பாடு விடுகிறது. அந்த ஐயப்பாட்டை நீக்குவதற்கு இந்த சிறப்பு கூட்டத்தினுடைய முக்கிய நோக்கமாகும். பஞ்சாப், இமாச்சல பிரதேஷ், ஹரியானா போன்ற மாநிலங்களுடைய விவசாயிகள் டெல்லியிலே கடும் குளிரும் வெயிலிலும் ஒன்றிய அரசின் அடக்குமுறைகளுக்கு ஆட்பட்டு நடுரோட்டில் 13 மாதங்கள் போராடி கொண்டிருந்தார்கள். அப்போது வராத உச்ச நீதிமன்றம் 3 நாள் போராட்டத்திலே இத்தகைய தடையான உத்தரவு பிறப்பித்தது என்று சொன்னால் இது முறையா, அரசியலமைப்பு சட்டத்திற்கு உட்பட்டதா என்பதை 3 சிறப்பு உரையாளர்கள் நமக்கு தெளிவுபட விரும்புகிறார்கள். அத்தகைய நிகழ்ச்சியிலே நாங்கள் ஏற்பாடு செய்திருக்கின்ற தலைவருக்கு மீண்டும் என்னுடைய நன்றியை தெரிவித்துக் கொள்கிறேன். மீண்டும் நேரத்தின் அருமை கருதி உங்கள் அனைவரையும் வருக வருக என வரவேற்று அமைகிறேன். நன்றி, வணக்கம்.
நன்றி. அடுத்தது தமிழக தலைவர் ஆசிரியர் 99 வயதில் எழுச்சிமிகு இளைஞராக தொடர்ந்து பல்வேறு பகுதிகளுக்கு மக்களை திரட்டி சிந்தனையை தூண்டும் பெரும்பணியை மேற்கொண்டிருக்கும் ஆசிரியர் ஐயா அவர்கள் வெளியூரில் இருக்கின்ற காரணத்தினால் அவரது கருத்துரையை பதிவு செய்து இப்பொழுது ஒளிபரப்பப்படுகிறது. காணொலி உரையை அப்போது நாம் கண்டு கேட்கலாம்.
Yeah.
The beloved President Dr. Devadas and other dignitaries on the dais, and our chief beloved and most esteemed educationist Sukhdev Bharat, and other friends and comrades. To welcome our former chairman, Wardon, and made his period as a golden period, because he was the one who always worked for the welfare and progress of the depressed and the downtrodden. The social justice is to be followed. What for? That is the main question. How the word social justice has gained importance during these years in our country particularly, because the depressed and the downtrodden have denied due legitimate rights. Article 46 in the directive principles of our Constitution clearly says social injustice must be annulled, and the depressed and the downtrodden weaker sections must be protected from the forces that insist and enjoy the social injustice. So when there is injustice, people want and people demand justice. This is why social justice was adumbrated in our Constitution particularly that too in preamble. So it is not a concession. When after a great fight by our predecessors, by our senior leaders, and all those fighters on the social justice, they secured only certain rights. Even to that extent, the oppressors doesn't want to enjoy that. Thousands of years we were denied education, we were denied employment, above all denied respect, dignity, even human dignity. We were made dehumanized. Only through social justice we could gain our rehumanization. That is why social justice must play a very important part. That we fought and got all these, the 69% in Tamil Nadu. But what is the strength of the so-called upper caste who wants to retain the social agreeable for that? If everything is to everyone, even the upper caste people are not denied their due rights, but only according to their population, proportionately. Why should they enjoy all? No, that is their philosophy is like a Dronacharya. They want to act as a modern Dronacharyas. They want to use the Supreme Court, High Courts also as a weapon to protect them. If our Supreme Court, that is the last faith for democracy, if those people want to support those who are standing on the side of social injustice, we will have to go to the people's auditorium. Makkal Mandram is very, very important because the sovereignty lies only in our people. And Baba Sahib Ambedkar, when he drafted the preamble along with his co-members, he told, we, the people of India, giving to ourselves, though sovereignty never lies in the presidentship or prime ministership or any other party, only through people. So majority of the people, they are tillers of the soil, hewers of the water. They are the sons of the soil. They want to have education because education alone they could build, rise their, through their, and through education they could be empowered. All these things, the only way is the reservation. And reservation is nothing but social compensation. Compensatory justice, that is what it is called. So, even though compensatory justice was not done according to the proportionately, but anyhow, what we got after we fought for so many years want to be retained. But when the Mandal Commission was announced by our Honorable Social Justice Savior, VP Singh Prime Ministership, those who are interested in killing that Mandal must be completely, thoroughly thrown out. They wanted to create artificial opposition by putting some student force and all these things. The same one is being repeated today, and they want to say, no, when IIT, when our boys and girls are entering after a very long time, the doors were open or broken. That is why the propensity to study is completely diverted. And that is why they are very particular in, they are depressed and oppressed. Some people with a weak mind, because of that atmosphere of mockery. Oh, you are from reservation category. This is a very shame. So, we want to discriminate and degenerate them, degrade them. They cannot tolerate. They are unable to fight against it. That is why that is being done in a small way. Even that remedy is opposed, and they want to use the courts to take it away as let the courts, whether Supreme Court or High Courts, they should not play and they should be made Ekalavas. The days of Dronacharya and Ekalavas are over. That we must declare and ready to fight for our rights. We don't want to have any concession. We are not begging with a begging bowl. We have got our rights. It is our human rights. And it is adumbrated in our constitution. We are the citizens of his country. So we have got every right to have the 3 R's to be socialized. No more the social monopoly. That is the message of today's meeting. And all our learned speakers like Karunanidhi.
Whenever new issues come, the crossroad for the discussion and guidance. With similar for Australia. In same case, this issue also you have given a very clear thought process about this issue. I sincerely thank Australia for his thought-provoking speech. Now, next we will move on. We are really privileged to have Professor Sukhdev Thorat, a renowned economist, educationist, and writer. He was a former chairman, University Grand Commission. In fact, he had joined this meeting from the beginning of this meeting. He has been waiting for address this August gathering. Before he addresses, I would like to say a few words about him. His academic work focuses on caste-based exclusion, education equity, and social justice and rural poverty. He has also authored about 70 research papers published in national and international journals. He had worked on more than 25 research papers. His research has shaped up national policy debates and inclusive marginalized communities. He has been awarded Padma Shri for his contribution to education and social sciences. Now I invite Professor Sukhdev Thorat to deliver a special lecture.
Good evening to all of you. Am I sufficiently audible to all of you?
Yes, sir. Yes, sir. Yes, sir. You are audible.
Yeah, good morning to all of you. I thank you for asking me to participate in this important meeting where you are discussing about the recent regulation brought out by University Grand Commission for the promotion of equity in the higher education. in 2016, 2026. This regulation led to an opposition by the generally a high caste student on various grounds, and the Supreme Court has accepted their petition and kept the 2026 regulation in abeyance, while the 2012 regulation continues. I would like to sort of give you the background of this regulation and how this regulation can be improved, for which we should try our effort. You know that there is a provision in the Constitution in Article 15 wherein the Article 15 state that there won't be any discrimination based on caste, religion, gender, tribal, and physically handicapped. Everybody will have equal opportunity and everybody will be equal before the law. The Article 17 also abolished untouchability, which involved discrimination, and it made a practice of untouchability is made a act of punishment. Now, Article 15(5) also empowered the state to take steps to improve the participation of the scheduled caste, scheduled tribe, and OBC
Recording in progress.
in the governance, in the government, and also in the educational institution. It also make a provision for reservation in the education institution. Now, as a follow-up of that, this provision of non-discrimination has been converted into a law to put into in practice. So we have Anti-Untouchability Act of 1955 and we have Atrocity Act of 1989, where everybody is not supposed to be discriminated, will have equal access to citizenship right and all right. Now these two acts, 1955 Act and 1989 Act, they generally confine to the sphere where education doesn't figure prominently. It only mentioned the discrimination associated with the admission to the school and the colleges is considered to be violation. But there are other spheres where there is a discrimination in education institution. The University Grant Commission should have brought the regulation for equity and non-discrimination much earlier. They brought the regulation for gender equity and sexual violence. They also brought regulation for the physically handicapped, but they did not brought out the regulation for non-discrimination, against discrimination in the education institutions. It is when I was the chairman of the University Grant Commission during 2006 and 2011, at that time, lot many cases of discrimination happened on the higher education campuses. There were suicide in All India Institute of Medical Science. I was asked to examine the reason of suicide, and the report came with a rampant practice of caste discrimination of scheduled caste and scheduled tribe, which result into suicide and another forms of discrimination in teaching and social life. So I pursued it, and finally in 2012, the then Education Minister Kapil Sibal took the initiative and the regulation were passed in 2012. So 2012 regulations are called Equity in Higher Education, which essentially have a provision against discrimination. It identifies about 25 to 80 sphere of discrimination in the higher education campuses, which it prohibit and provide a safeguard to the person who became victim of caste and untouchability discrimination. But despite this law, the discrimination didn't stop. There were suicide and very prominent suicide of Vemula. It was followed by another suicide in Bombay Medical College by Payal Tadvi. It was again followed by a suicide in the IIT Mumbai, Solunkef, and a couple of other suicides. And the mother of Payal Tagdi and Vemula went to the Supreme Court in 2019 and asked the Supreme Court that for the proper enforcement of 2012 regulation and also some improvement in the regulation, because despite the regulation, the discrimination continued and the suicide as a result of discrimination also continued. The case was taken by Disha Wadekar and other senior lawyer. The Supreme Court then asked the UGC to give the existing status, and UGC reported to the Supreme Court that only half of the institution had implemented this regulation and set up the Equal Opportunity Office, and there were very less cases of complaint. But UGC also then the Disha Wadekar and lawyer asked for the improvement in the 2012 regulation, and Supreme Court also asked to improve them, and that is how the 2026 regulation came into operation, to which the general student has begun to oppose. Now there are limitations within 2006 regulation, which with those limitation, we have to ask for the removal of those limitation, and with those removal of limitation, then 2026 improved regulation should be practiced. The Supreme Court should not succumb to the demand by the high caste and a general student. The limitation of the 2026, there are three limitations, which there are two prominent limitations which I would like to mention before you. One is that in 2012 regulation, they defined the discrimination, but they identified about 25 forms of discrimination. And if somebody practices that kind of discrimination, he or she is subject to punishment. But the 2026 regulation has removed those list of the discrimination, and it left a listing of the discrimination to the Equity Committee. There is a provision of Equity Committee now in 2006 regulation. Now, this is a very serious mistake, because Equity Committee, which consists of a Vice Chancellor and principals and some professor, they are not capable of making the list of discrimination being faced by the scheduled caste, scheduled tribe, and also OBC. These are very complicated forms of discrimination. Therefore, the demand should be that there should be listing of discrimination should be incorporated in the 2026 regulation. In fact, the standing committee attached to the Ministry of Education has recommended that. That committee is headed by Digvijay Singh. That standing committee has recommended that there should be a list of the forms of discrimination, because Untouchability Offence Act also lists about 20 forms of discrimination. Atrocity Act also lists about 40 forms of discrimination. So it is easy for the student to know that this particular behavior constitutes discrimination, and then he can complain. So I think that is one of the limitations which has to be overcome. There are other minor limitations. Those limitations should be brought out. I have in my article in New Indian Express, I have mentioned those limitations. In Hindustan Time paper also, I have pointed out those limitations. If those limitations are overcome, with that improvement and strengthening of the 2026 regulation, we should sort of accept it. There is other limitation that I would like to point out, although there is no clarity on that. As far as the regulation 2026 is concerned, although it talk about all the educational institution, center and the state, but in the definition of the institution, generally it confined the education institution which are under the section of the UGC, section 3 of the UGC, which only covered the universities and the colleges. Now there are several other institutes. IITs are under the IIT Act of 1961. The managements are under the Act of 2017, self-standalone institution which offer diplomas and all. They are under AICTE, All India Council of Technical Education. Agriculture universities, colleges are under Ministry of Agriculture, Indian Council of Agriculture Research. The law universities and colleges are under Bar Council. Similarly, the medical colleges and university are under Medical Council. There is no clarity whether all these institutions will be covered. My suggestion would be, which we should put forward, that this regulation need not be brought out by UGC and Ministry of Education. It should be brought out by the central government, and saying that all education institutions which are covered under all the ministries. For example, the National Defense Academy and other institutions are under Ministry of Defense. There are some institutions which are under the Ministry of Home. So if there is a central regulation which is applicable to all the institutions in the country, there are about, I think, 63,000 institutions of various types. So that is one suggestion we should make to the government. The last important point is that this equity committee, which is consist of 10 members, there is no provision of reservation for scheduled caste, scheduled tribe, and OBC. We should ask that at least 50% of the member, out of 10, at least 5 should be from SC, ST, OBC, and of that, half of them should be women. So these are some of the limitation of 2026 regulation, which should be brought in. Now the demand of the I will make a last point. The demand of the these students who are agitating, they filed the petition in the Supreme Court, and Supreme Court also lent some support to their argument, which is very disturbing and surprising. One of the major their argument is that in the 2006 regulation as well as in 2012 regulation, it gives the definition of discrimination and differential treatment, and include the category of discrimination based on religion, caste, ethnicity, gender, physically handicapped, and even economically weaker section. But it also specifically mentioned about the caste discrimination of scheduled caste, scheduled tribe, and OBC. Now, the objection of this general student is that this clause of caste discrimination should not be there. Caste should be included in the general forms of discrimination. And they are making the argument that this will divide society. On this, there will be a division on the campus, that there will be false cases and misuse of this. I think these arguments are not correct. In 2012 regulation also, there is a separate mention of caste discrimination of SC, ST, and OBC, and then there is general provision in which caste also figure. What is required is that this special provision of caste should be mentioned, but also the listing of the discrimination for each of the categories should be separately maintained, prepared, because the caste discrimination is different from the tribal discrimination. Caste and tribal discrimination is different from the religious discrimination. Then the discrimination associated with race of Northeastern student is different. The discrimination association with color is also different. So for each of the forms of discrimination, there should be a separate list, and they should be mentioned. So I think the argument that is made by them and supported by the Supreme Court to a certain extent is not correct. I think there is going to be next hearing on March 19th. Before that, we should make this recommendation that the provision of the 2026 regulation wherein caste is maintained separately and also other forms of discriminations are maintained separately, these should remain. There is no any risk of division on the campus. The 2012 regulations were there for last 11 years. We have not seen division. In fact, the regulation bring the people together, because the regulation not only has a provision of action against discrimination, but it has also a sensitization program for high caste student. So students are sensitized that whatever values and norms they acquire in the family of inequality and other thing, antisocial attitude, they should be removed. So there should be uh, the sensitization will bring the student together. It won't divide. And secondly, that the scheduled caste student, scheduled tribe will make false cases is a very obnoxious argument. For last 11 years, the 2012 regulation is in practice. There is not a single case of false cases against the high caste. Besides, Dr. Ambedkar has provided an explanation to this, that scheduled caste, scheduled tribe in the villages and even the colleges, they are so weak, they cannot have a courage and strength to make a false case against the high caste. Why should they make a false case? So this is a indirect opposition to the regulation by the high caste student. This is not, they are not pointing out the limitation in the regulation. Main purpose is political and ideological. So the purpose is that caste discrimination will be exposed in the school and higher education. They don't want to bring out this, the defects of the caste system and the Hindu social organization. So I think these are some of these suggestions that I have made should be incorporated into 2026 regulation, and we will insist that those regulations should be passed and implemented by the UGC. The enforcement mechanism mentioned in the 2026 regulation is reasonably good, because the education institution which do not set up the office, equal opportunity office, they are subject to action by the UGC. There will also be a oversight committee with the UGC. So there is a deterrent on the institution that they should follow this. And the procedure is fairly strengthened, because I think they borrowed it from the Ragging Act. Ragging Act has been very successful act. Ragging has been almost minimized and reduced. So they have taken several provision for the enforcement. So I think with those with this improvement, this 2026 regulation will be good. We should insist for that. We should insist on Supreme Court and that this act should be strengthened, so that discrimination stops, suicide stops. Well, with this observation, I would like to thank you again for holding this discussion and inviting me. Thank you very much. If you have any question, I am willing to answer.
Every one of us have a lurking fear that justice will be derailed in this case because of observations. Because of the observations made by the justice.
Sir, come closer, please. Come closer to the mic, please.
Every one of us have a lurking fear that justice may be.
Please take the mic close to your mouth so that I can listen.
Sir, is it audible, sir?
Now it is audible. So
Am I audible?
yeah, now audible. Earlier was quite audible. So
Yeah, please.
I am John Sundar, a former director from
Lok Sabha Secretariat, Parliament of India, we all have a lurking fear that justice may be derailed in this case, because the way in which the comments may be made by the justices at the time of admitting this case. The second hearing is going to be there. By the time, as suggested by the former UGC vice chairman, we have to go to them with suggestions like adding further teeth to the latest regulation of 2026. But I'm afraid that may give a handle to them to further postpone the implementation of this new regulation of 2026. Instead, the case should be decided very soon so that the 2026 regulation takes place, because it focuses on the caste discrimination, especially by the students from the deprived sections of the society. So we may put forth a prayer that the court should direct the UGC to go in for taking the public opinion to make suitable amendments thereafter. That is one thing. Another suggestion, Government of India can take over and bring about a law that can cover all the education institutions. Yes, that should also come as a suggestion. They well taken by the Supreme Court in its judgment, and before that, they should be impressed upon enough by legal luminaries to implement this particular 2026 UGC regulations. That should take place first. All our suggestions, well-meaning suggestions, should come as a well-taken suggestion from the Supreme Court itself. Am I not correct? Thank you.
Yeah, Professor, you can start now. Professor Thorat?
Yeah, tell me. No,
No, 1 minute, sir. 1 minute, please.
I said that if there is a questions, I will answer.
Sorry, sir.
If there are questions, I will respond. My lecture is over.
Yeah. We understand, sir. And the question will be shortened now. Okay. Okay.
Any question, he has suggested few measures.
Questions. நீங்க எங்க வச்சு
Sir, we know with our stand that in the committee there should all representatives from the scheduled caste and other OBC. It is a good suggestion. My question is, does this Supreme Court judgment torchlight towards the need of reservation in appointment of Supreme Court judges, as our leader Tamil தலைவர் always insisting?
Hello?
Yes, Professor.
No, this was your question?
Yes, sir.
Yes, sir. Is there a
No,
need? Is
the
there a
point-
need for reservation in judicial sector?
Yeah, but we are discussing the regulation. There is, of course, a need for reservation and representation in judiciary at all levels. There is no doubt about it. Yeah. Dr. Ambedkar in early 20s, and he asked for the reservation in judiciary. And he also argued that there is a discrimination in judiciary, so there should be a representation of scheduled caste, scheduled tribe, and other section in judiciary.
Thank you, Professor. So the first question is being repeated now in short way.
Is the mic on?
Yeah.
I think. Okay. When I was expressing my lurking fear, when I was expressing fear about the way in which it is being tried, it is necessary that more interventions are there, intervention petitions are there. They go to Supreme Court and should come with a point that which should be educating, informing, and enlightening the judiciary itself, the justices who are going into this case. Because the way in which the comments were made in a loose fashion, as though it is emanating from their loose sally of mind, was unfair. So is it not necessary to strengthen the argumentative points to be presented before Supreme Court? Number one. Number two, before praying for an all-encompassing legislation, we should see that this is tried as soon as possible so that this 2026 regulation is implemented very soon. So further amendments which were suggested by you cannot be taken later, because our focus should be to see that caste discrimination is different from ragging, as you rightly pointed out. So my question to you is how to focus and see that this particular trial is tried and we get justice. Thank you.
See, listen, the Supreme Court has issued an order, and they have, there are 5 type of prayers in that order, which will be taken for consideration on 19th March 2006. We cannot change that. That's a Supreme Court order. There are 5 prayers. One prayer is that the caste discrimination should not be mentioned separately. That ragging should be made a part of this regulation. They have also brought in something which was not said by the petitioner, that how this regulation may apply within the subcaste among the scheduled caste. So there are 4-5 prayer which will be taken up on March 29th. I think what we have to do is that we should write as many petition and as many letters and memorandum to the Supreme Court on this issue. That is very important. You cannot stop the hearing of the Supreme Court on 19th, which is fixed on 19th March. I think we should also file petition with our viewpoint, asking for improvement on this line. I was the petitioner for the earlier case. I will try to become a petitioner and submit a memorandum, academic memorandum for improvement in the 2026 regulation. So we should, and what they are saying that they will set up a committee of 3-member judges. If they take a decision to set up a committee to review the 2026 regulation, I have requested that some Dalit academicians should be included in that committee, and we should give a lot of memorandum to this committee when the committee is formed.
Please. Question, sir.
This is Swaminathan Devadas. Perhaps you remember me. I lived in very close to JNU in Munirka. Many times I visited your residence.
Okay,
And
thank you. Thank you.
As a personal manager. And a couple of times I visited your office in UGC, I think way back in 2006. It is truly very insightful discussion, and your speech, interesting, it is very inspirational. you explained the false complaints during your tenure, a 6-year tenure in UGC. After the 2012 regulation, you said there was no such complaints brought out. But I read your Indian Express, your article in Indian Express. You mentioned there are two issues on which are making their case and they're opposing the regulation 2026. So my question is, they're talking about reverse discriminations. The scheduled caste, scheduled tribes, and the campus be these people will have a majority in number, and the upper caste people, the people who are opposing this regulation, they are afraid of being or getting into a smaller number. Is it true? Will it happen? Reverse discrimination is really going to be a reality in the campus once 2026 regulation comes into force. Thank you, Professor.
See, you must understand the argument of reverse discrimination. What they are saying is, in the prayer, they have not talk about reverse discrimination, but there is an indirect mention. Reverse discrimination means that this is argued by the high caste student, that but reverse discrimination is the case which is argued for the reservation in jobs, not for this, but they have deliberately brought it here. Reverse discrimination means that you are giving a reservation to the scheduled caste, scheduled tribe, OBC, and the general candidate which are better than scheduled caste, scheduled tribe, OBC, they are not given the positions. As a result, they are saying that there is a reverse discrimination of high caste. But that argument is not also sustainable. But in the case of regulation, this regulation, there is no question of reverse discrimination. If the high caste do not practice discrimination, there won't be complaint against them. And so there is no argument for reverse discrimination. The second thing which we have to understand is this, because there is a lot of mispropaganda, misinformation. See, in the 2026 regulation and even 2012 regulation, anybody who practices discrimination in any form is subject to punishment. For example, if a scheduled caste, scheduled tribe and OBC discriminate against women or discriminate against physically handicapped, even they are subject to punishment. So there is no question of only high caste being complaint against high caste are only made. So this is a very inclusive regulation where any section, SC, ST, OBC, Muslim, woman, if they observe discrimination of any kind, all are subject to punishment. So I think this argument that only high caste will be subject to complaint and is not a proper argument. It is just made out of political intention.
Thank you.
Okay. Sorry. I'll close பண்ணலாம்.
Thank you, Professor, for your Thank you, Professor, for your impactful address and clarification. In fact,
Thank you.
Professor brought out in his address the various developments occurred before the new regulation 2026, and also he brought in, he elaborated the few limitations in the regulation and made various suggestions to take it forward. Thank you, Professor, for your
Shall I?
clarification.
So I will leave now. I will leave it to you for discussion. Okay.
Thank you, Professor.
Bye.
And our external secretary of Dravida Kazhagam and general secretary of AIOBC associations, Mr. G. Karnani is going to address here, and we will discuss your ideas and we will discuss your viewpoints about this UGC rules and regulations. Let us go towards egalitarian society, and our beloved Asrier, our leader Dr. K.Veeramani, wishes to convey his regards to you.
Thank you. Convey my regard to him as well. Yeah, I will also send you other literature so that you can, it will help you to take a position. But file as many petition as possible and send as many suggestion as possible to Supreme Court, to UGC, and when the committee is formed, also give many suggestion to that committee. Thank you.
Sure, Professor. Sure, Professor.
Thank
On behalf of our students' organizations all over India, we are discussing to conduct seminars and agitations towards this. Every work is going on now. Thank you for your kindness.
Pleasure. Thank you.
Thank
Okay.
you.
Good night.
Thank you. Thank you, sir. Thank you, sir.
Recording stopped.